I'll now call the meeting of the Committee of Adjustment for February 17th, 2022 to order, and I will start with reviewing the following ground rules. Good evening, members of the committee, applicants, agents, staff, and members of the public. As this meeting is being held electronically due to the COVID-19 pandemic, I'll go over some ground rules of procedure for the benefit of members and the viewing public. This meeting is being recorded and streamed live via the County of Brant YouTube account. To all of those attending the meeting, please ensure your camera is off and your microphone is on mute throughout the meeting when you are not speaking. When it is appropriate to speak, please remember to unmute your microphone and turn on your camera if operational before speaking. I would ask that, if possible, Committee of Adjustment members use their cameras throughout the meeting so that applicants, agents, and members of the public know who the members are. Staff will be requested to join the meeting during presentations and will be available to answer questions. Movers and seconders of each motion will be identified by the committee members, and a recorded vote captured by a yes or no by each committee member. Applicants, agents, owners, and delegations are participating via Zoom or telephone accordingly. All persons wishing to speak to the items on the agenda were required to register prior to the meeting. Any delegations received in written format have been provided to the members of the committee and will form part of the meeting record. Those presenting as delegations will have 10 minutes to speak to the application at hand, not past applications or associated applications. Staff will have a timer for 10 minutes and will give the delegation a 2-minute warning. If the delegation presentations are not focused on the application at hand, the chair will ask the delegations to focus their presentations. In the event a connection or service interruption occurs that affects quorum of Committee of Adjustment, we may recess the meeting for up to 15 minutes to regain quorum. If quorum is not achieved, the meeting is adjourned. I'll now introduce Kayla Delay to provide her comments.
Thank you. Good evening, ladies and gentlemen, and welcome to tonight's Committee of Adjustment meeting. Due to the COVID-19 pandemic, rather than a traditional meeting in the council chambers, this virtual meeting will act as the statutory meeting for the Committee of Adjustment planning applications. The purpose of this Committee of Adjustment meeting is to give consideration to minor variance and consent applications. Public notices were mailed and signs were posted by staff as required by the Planning Act. A copy of the meeting agenda, including a staff report, related materials, and comments received have been posted on the County of Brant website. This evening, the committee will hear from planning staff who will share an overview of the application and provide their recommendation. The committee will then hear from the agent or applicants and any members of the public who have registered to speak this evening. Following each presentation, the committee will have an opportunity to ask questions of clarification. Once presentations, public hearing, and question period are complete for each item, if the committee deems it appropriate, they will make a decision. The names of those individuals who speak on any item will appear within the meeting minutes, and anyone wishing for further notice of any hearing, including a copy of the decision, can contact the Secretary Treasurer for the Committee of Adjustment. Minor variance decisions are final if there are no appeals within 20 days after the committee's decision, and consent decisions are final if there are no appeals within 20 days after the notice of decision has been issued. Representing planning staff this evening include myself, Kayla Delay, and we also have Brian Cummins, Shannon LaBelle, Amanda Wazinski, and Alyssa Seitz. And that's it for me, and I'll turn it back over to you, Member Brown.
Thank you, Kayla. I'll now ask the committee to indicate if you are present by stating present, if you are in attendance. Mary Jane Brown, present. Harry Emmett,
Present.
Thank you. Bob Hamilton,
Present.
Daniel Zuloff,
Present.
Steve Schmidt,
Present.
John Vamus,
Present.
thank you. And I'll just note that member Rebecca Smith is absent. We will move to item 2 on our agenda, approval of agenda. Do any members have items to be added to the agenda? I believe there are none. May I request a mover and a seconder?
Member Emmett, moved by myself seeking a seconder that the agenda for the County of Brant Committee of Adjustment meeting of February 17, 2022 be approved.
Thank you, member Emmett. Do we have a
Member
second?
Schmidt will second.
Member Schmidt will second. Thank you,
Yeah.
member Schmidt. Members, please indicate if you're in favor of the motion, starting with member Emmett,
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The agenda has been approved for tonight. We will now move to item 3 on our agenda, declaration of pecuniary interest. Are there any members who would like to declare a conflict of interest for any items on the agenda this evening? If yes, please indicate by stating your name and application number.
It's member Zuloff. Yes, I have a conflict with item 6.5. That's application B7821AW.
Thank you, member Zuloff. So noted in the minutes. And I will ask that when that application is presented, you do stand aside. We will now move to item 4 on our agenda, adoption of the minutes from the previous meeting. Do committee members have any errors or omissions to note? I believe there are none. Can I ask for a mover and a seconder for this motion?
Member Zuloff, I can move this motion if there's a
Thank
seconder.
you. Do I have a
Bob
second?
Hamilton here. I'll second the motion.
Thank you. Can I
Okay.
have member Zuloff state the motion?
Yes, moved by myself and seconded by member Hamilton that the minutes from County of Brant Committee of Adjustment meeting of January 20th, 2022 be approved.
Thank you, members Zuloff and Hamilton. Members, please indicate if you are in favor of the motion, starting with member Emmett.
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The approval of the minutes has been adopted from the previous meeting. The minutes have been approved. I will now move on to item 6 on our agenda and introduce the item 6.1 application A121DN and turn it over to staff for the presentation of the report and the recommendation.
There we go. Thank you, Madam Chair. This is a minor variance application A4121DN for the property located at 68 Meisner Road. The agent is with us this evening and staff are recommending approval of this application. So this one will look familiar to the committee members, and I'll refresh your memory shortly. But the subject lands located at 68 Meisner Road are located just south of the city of Hamilton boundary, north of Jerseyville Road. I should note that the frontage on the property has about 90 meters on Meisner Road and a current area of 15 hectares or approximately 38 acres. The subject lands identified in the blue and red outline are designated as an agricultural land use with the natural heritage area identified in green. And in our zoning bylaw, the lands are zoned agricultural with natural heritage, again, identifying the natural features on the property. The proposal is requesting relief from the zoning bylaw to recognize the proposed deficient lot area of 14.77 hectares from the existing legal non-conforming lot area of 15 hectares, and the zoning bylaw requires 40 hectares. So this application is required and is a result of the previous consent application from September 2021, which was 2021. This application, which I have the concept up on the screen, I proposed to add a small portion of land identified in red to the abutting parcel identified in orange. And it was a condition of that consent application that a subsequent application be submitted to recognize the result, the reduced parcel area. So again, the existing area prior to the boundary adjustment was 15 hectares. And this is already deficient from the 40 hectares required. And as a result of the boundary adjustment, the area would be reduced to 14.77 hectares, being recognized or requested to be recognized through this application. Review of this minor variance application has had regard for the 4 tests as set out in section 45(1) of the Planning Act, and comments received as part of the technical circulation. I confirm that no public comments have been received as part of that public circulation, and it is my professional recommendation that this minor variance application be approved. Happy to answer any questions.
Thank you, Dan. Does the committee have any questions or comments to staff?
Member Hamilton here to the staff. Dan, is this something that's going to pop up more often? We haven't had to do this very much in the past, if ever, and I was just wondering, as things come forward, will this be something that will have to be done for anything less than that 40 hectare minimum?
For you, Madam Chair, to Member Hamilton, that's a great question. I was thinking if the committee has dealt with this situation through a minor variance up to this point, it is something that we've been doing over the last 2 years, recognizing that any change in a legal non-conforming situation like a deficient area should be recognized through a planning application. And the committee wouldn't see a lot of these because most of them are being dealt with through a zoning bylaw amendment wrapped into the A9. So as a result of the surplus dwelling. So most of these requests are going through our planning and development committee wrapped into one application.
Thank you.
Thank you. Are there any further comments or questions from the committee to staff? It appears there are none. Is the agent or applicant present to make to add to staff report or any further details?
I am present. I don't have anything to add. It is a minor type application and necessary, I think, to confirm the Lundy Farm remains a legal undersized farm. So we need to proceed.
Thank you, Mr. Lefebvre. I'll ask the committee, do you have any comments or questions to the agent? It appears there are none. So I'll just ask the committee, are there any final questions or comments to staff and or the agent applicant? Again, it appears there are none. I will now request a mover and a seconder to put forward a motion on this application.
Member Hamilton here. I'll move for the this application. If I can have a seconder, please.
Member Schmidt.
Thank you.
Thank you. Moved by myself and seconded by Member Schmidt that application A41-21-DN for a minor variance be approved.
Could you please state the reason why you've put forth this motion, Member Hamilton, in keeping with the
Well,
intent?
Okay, you've got me a little confused here. I've put it forward to what it does to follow, because there's no real conditions with it. So I'm just going for the approval, I guess, unless
Okay.
somebody needs somebody can tell me what I need to say.
I think it was suggested that, like in an application like this for a minor variance, it meets the test of a minor
Oh.
variance. So that would be your reason to approve.
Thank you. Okay. And I will move by myself, second by Member Schmidt, that application A41-21-DN be approved because it meets the 4 standards for a minor variance.
Thank you, members Hamilton and Schmidt. I will now call the vote. Members, please indicate if you are in favor of the motion, starting with Member Emmett,
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The application has been approved. Thank you, committee and staff. We will now move to item 6.2 on our agenda. I will now introduce that item 6.2 for application A3221RC and turn it over to staff for the presentation of the report and the recommendation.
Madam Chair, I trust everybody can see my presentation here. I'll proceed. Thank you.
Yes, I can
This
see
is
it.
with respect to application A3221, minor variance application for 507 Scenic Drive. Subject lands are located on the north side of Scenic Drive between East River Road and McPherson School Road. The subject lands currently have a frontage of approximately 54 meters in an area of approximately 0.63 hectares. The subject lands are privately serviced by both private water and wastewater servicing. The applicant is proposing the following minor variances in order to facilitate the construction of a detached accessory structure. It would be a minor variance for a maximum total accessory structure lot coverage of 185.77 square meters, whereas 140 square meters is permitted, and a maximum accessory structure height of 6 meters, whereas 5 meters is permitted. Subject lands are designated as rural residential in the County of Brant official plan. This designation allows for limited low density residential development within existing clusters. The subject lands are currently zoned as rural residential RR. And again, the applicant is seeking relief from section 4.4 of the zoning bylaw with relation to accessory structure provisions. And this is to permit an increased accessory structure lot coverage and building height. To date, through the circulation, staff have received a number of letters of concern from members of the public. Items of concern related to the size of the structure, potential for a business to be operated out of there, and also the perception of perhaps a precedent being set for the neighborhood in general. Staff is of the opinion that the application is minor in nature and meets the general intent and purpose of the zoning bylaw and official plan, and is desirable for the development of the lands, as outlined in my report, and therefore it is my recommendation that this application be approved. Happy to take any questions at this point. Thank you.
Thank you, Ryan, for the presentation. I'll ask the committee, do you have any questions or concerns to staff?
Member Hamilton here. Ryan, just through the chair, just looking for clarification. We are talking about approximately a 2,000 square foot building now, not a 3,000.
Madam Chair, that's correct. I believe comes out to 1,999 square feet. Yeah.
And what we know is 1,400 square feet is allowed currently, and he's seeking a 33% increase in the size of the building.
Again, forgive me here. Okay, so it's 140 square meters, which is currently permitted, which is approximately 1,500 square feet. And I believe that's about 32 or 33% increase. That's right. Thank you.
Thank you.
Are there any further comments or questions from committee?
Member Emmett here through the chair to staff. Does staff know? Does staff know if this we use just for the private use and not a commercial use?
Madam Chair, the applicant's submissions have stated the intent for this building is for personal storage of goods and recreational vehicles, and has made no indication that it's for commercial use.
Thank you.
Thank you. Are there any other comments or questions from the committee? I have some questions, but I think they would have to be directed to the applicant. I will note that I did email Ryan on it. I'm not sure if the other committee members saw the email. And my question to him was the size of the house, and he did confirm the house is approximately 3,200 square feet. So if that's some information the committee members would find useful. So I believe, unless there are further comments or questions from the committee members, I will now move to ask if the agent or applicant are present to make a presentation or add any details to the staff report.
Good evening, Madam Chair and committee members. My name is Ruchika Angrish, and I am acting as the agent for the homeowner at 507 Scenic Drive. I do have a very short presentation if I'm allowed to share my screen.
Please go ahead.
Okay, if somebody can confirm they can see my screen.
I can see it.
Okay, thank you. Thank you again, everyone, for your time this evening to hear this application for a minor variance on behalf of the owners of the property at 507 Scenic Drive. I'm not going to go in the same details which Ryan has already presented, so I'll just simply skip this slide. Our original proposal was for 270 square meter accessory structure. The size of the structure itself was 200 square meters, but however, the owner wanted to have covered porches just for some outdoor enjoyment. And as the zoning bylaw states, any covered porches are also considered part of the lot area or lot coverage calculations. So through the original application, when this was originally circulated in October or fall of last year, we got a number of concerns from the residents, and based on further discussions with the owner, we have revised the proposal, removed the covered porches, and revised the size of the garage to approximately 86 square meters. The height of the structure still remains at 6 meters. The reasons that have been provided is because of the storage of recreational vehicles, a boat, and a RV that the owner is planning to purchase. We have read through all the letters that have been received, a number of letters. The concerns were addressed through the revised submission that was provided to the county. There's no home occupation, no commercial business that is being run on this property. The structure is strictly going to be used for residential storage and personal use. There were a number of concerns that were raised about the views, the rural character. I would like to point out to the committee there, we did a little bit of research, and there's a number of applications beyond 200 square meters that have been approved by Committee of Adjustment through minor variance applications in last couple years. This information was provided to the county with the revised proposal as well. In terms of views, I would like to note that these are large properties, large estate lots, and large backyards. So if from one angle the view is obstructed because of a garage, then there's enough area at the back of rural properties for their enjoyment. So it doesn't obstruct anything. The location of the property or the location of the garage is a bit restricted, as you can see from the site plan on screen. There's septic system on the other side of the property, and because of the grading and how the system works, that's the only location where we can put the garage. A number of trees have been planted by the owner. They are babies at this time. If somebody had done site visits, and again, we did note some addendum letters that came in. That doesn't mean that the trees are not going to grow. So that will provide a privacy screening for some of the concerns that have been raised in terms of overlooking on an accessory building, from someone's windows. There were concerns about impact to the wetland. We have received comments from Grand River Conservation Authority. There will be a permit that will be applied. They did not object to the minor variance application. So this will be addressed through the GRCA permit. Grading and any such concerns will, again, a grading plan was provided to the county, even though it has not been accepted, because we still need to go through a building permit application process. But overall, the grading of the property will work, and it will not have any impact on the adjacent wetland feature. I don't believe that there will be any impact on groundwater because of the garage. And some of these comments that related to a commercial business that is being run on this property. The owner does run a commercial business, but not on this property. He has a commercial vehicle, which he parks at the end of the day. The owner has mentioned that it is part of his retirement plan within next 5 to 10 years that he's going to retire from his commercial business and then enjoy the property as it sits. So this whole application started with a complaint from the commercial vehicle parked on the property, and lead it into if he's planning for a garage for the storage of that commercial vehicle, which is not permitted to be parked on the property itself. Then he started thinking about what he wants to actually achieve from this building permit application, and it resulted in a minor variance application, which is in front of you. So as for, again, we still believe that it meets all the 4 tests. It meets the intent of the official plan. There have been a number of other variances that set an example. Even though every minor variance is looked at for its own merits, we still believe that it is needed for the development of this property. And we request that the committee approves this application. Those conclude my comments.
Thank you, Rushika. I'll ask the committee members, do you have any questions or concerns for the agent?
Member Hamilton here. I have a couple of questions I'm looking for clarification on. If you don't mind, please, through the chair.
Go ahead.
Number one, I'm still trying to understand why we need to have a 6-meter building over 20 feet in there for going? Because that seems a little excessive when 5 would actually handle most things from that situation.
Through you, Madam Chair. My understanding is because of the height of some of the recreational vehicles that the owner is looking to purchase, he needs that extra 1 meter height for those vehicles to be parked in this garage. At this time, the zoning bylaw does not allow storage of recreational vehicles on the property. They have to be covered. So that extra height will assist in the storage of these large vehicles.
Second of all, I guess what I'm wondering is the applicant planning on having water and a washroom out in this building as well?
Again, through you, Madam Chair, my understanding is not. At this time, there has been no discussion about having any kind of washrooms or any other facilities in this garage.
Thank you. And the third question I have is the applicant currently has a large home with 3-car garages, and to add 2,000 feet of storage almost seems a little excessive to me when he's already got those, if he's planning on retiring and not needing those parking for commercial vehicles. I'm just wanting to know, I am right, there was a 3-car garage there, right? And he wants to put this 2,000 square foot with another 3 large garage openings in the building, correct?
Through you, Madam Chair. My understanding is that the existing garage is used for storage of household stuff. It's just kind of a junkyard, which that is the reason why the vehicle cannot be parked in this garage. And while we do talk about the retirement, he's not looking for a retirement next year where he can empty out the garage and release the commercial vehicle that his business is. So we're talking about 5 to 10 years. When we are looking at construction of a garage, my understanding is he's looking at from a long-term perspective when he can actually enjoy the property with, other accessories that they are looking for. So that's what my understanding of the situation is, and there's a reason why this additional garage space is being proposed.
Thank you.
Thank you, Member Hamilton. Are there any further questions or comments from the committee?
Member Emmett here, a couple for your chair. One, has there been any diagrams or suggested layouts of this storage building as far as the outside finishes and the appearance of the building to go along with the area?
Through you, Madam Chair, we did provide elevations to the county at the time of the original application. But since then, we have revised the application. The owner didn't want to spend too much time and effort into knowing what the outcome of the revision and how many revisions we needed to do. We've revised it a couple of times. So that's the reason why the elevations themselves were not updated to reflect the current 185 square meter garage structure, but and also there wasn't any request from the county to ask for the revised elevations or how this structure is going to be look like from the neighbor's perspective, or will it match the surrounding area? But we provided a couple drawings at the time of the application.
And secondly is From the diagrams that I have, I can't really tell how close to the property line the structure will be. Could you, will we need a minor variance on down the road for that or not?
Through you, Madam Chair, we do not need any other variances. I believe the requirement is 1.2 meters, which is about 4 feet, and we are about 3 point some meters. So from the side property line, so we don't require any additional variances.
Thank you.
Thank you, Member Emmett. Is that all your questions then?
For now.
Thank you. Are there any other comments or questions from the committee? Go ahead, Member Baines.
Member Bamus, through the chair, I have a question for the applicant. Just currently, how many occupants reside there, live in the house there at 507 Scenic Drive?
Through you, Member Bamus, or through you, Madam Chair, to Member Bamus, that is something I did not ask, and it is not part of, the planning rationale in terms of how many members live in the house.
I was just curious. Okay.
Do you have any more questions, Member Bames?
No.
Okay, thank you. Does the committee have any further questions? I have some questions following Member Emmett's comment on the drawings. I received from Ryan, as they were the drawings that were submitted, as you pointed out, Rashika, in the initial application. And one of the questions I had, because now it sounds, at first I thought there was an RV already purchased, so there are no recreational vehicles owned right now to go in the building.
That's a good question. I was hoping that the owner was able to join, and that's a good question. My understanding is, as of right now, he does not own an RV, but he is actively looking to purchase one.
Because the drawings, based on what I see, so you're saying the new proposed building is essentially the same as what those drawings show, which they showed a mixture of steel siding and brick, but they're lacking the porches. But then when I look at the drawings for the overhead doors, they don't appear to be significantly high. They look like a standard sized garage door that would be similar to what's already on the house. Am I correct, or am I interpreting those drawings? Because I can't really see the height measurements.
To answer your question, Member Brown, it's those drawings, when they were originally proposed or submitted to the county to review a building permit application a few years ago, it was proposed as simply a garage. But things have changed in terms of how the application for a minor variance came in front, and the owner started thinking about various other aspects while he's applying for a garage, which is a significant investment for a homeowner. And these drawings will need to be amended, and they need to be amended both on the size as well as the look of the building itself, and the height of the garage, like the garage doors. So all these things will have to be amended. The owner, again, it was just the interest of spending that extra resources to get to that point. We were not sure how many times we would have to revise, and that was the only reason why the owner chose not to worry about it at this time. But if that is something, again, we can certainly, at the time of building permit, we can address any other comments or things that are raised through this minor variance. If there's any additional conditions, we can certainly look at that.
Thank you. I'd only comment that I have difficulty trying to justify the minor variance with height increase when I'm not sure even what, generally we have drawings that would show there's an RV there, it's quite large, and then the overhead door is much more like those in agricultural buildings. So that's why I'm questioning why a significant height if you don't own the RV at this point. The other question I had, in the drawings, it showed that the location of the building, I guess that's to the west of the septic tank. And that's in quite close proximity to the neighbor. My question, and I guess it's may have been answered because there is a slope and there's some wetlands. You pointed out there's no other location on this lot for a garage. Like, could it not go down? Could it not move more to the northeast of the property?
My understanding is because of the location of the septic, and if we have to meet all the setback requirements, that's the location. We can understand, we really appreciate the neighbor's concern. But if you move the building from this neighbor's yard to other neighbor's yard, then we will get the same kind of concerns. You know, so it's not sure. But
well, I was just wondering if there was room, because it then is down the slope more. And that was my question, because it looked to me like there was a significant amount of land on the other side of the septic, but if there isn't.
The other issue that will come is if we are parking vehicles, then you have to go all the way around. That will be a long driveway all the way back to the other corner of the property. So that, again, just looking at all the logistics, that this area made most sense. And yeah.
It's just that when I look at the way the driveway goes to the house, it could basically go either way. It could go to the left or to the right around the house to the potential garage. And it seems to be that the septic is sort of in the middle of the lot. So yes, I can see there may be some planning challenges about the location. So I don't have any other further questions. I'll just ask if their members have any further comments or questions. It appears there aren't. I believe there are some public delegations registered to speak to this application. So I would ask now to please state your name and address for the record, if you are a public delegation for this application. And I believe the names were Michael Yeager and Trevor Sharp, and in my script I have a David Cash.
Good evening, Madam Chair. I'm Michael Yeager. I'm counsel for Trevor Sharp. If there's time, Mr. Sharp probably wants to say a few things as well, but I'll be giving a bulk of the presentation. He may help me with some of the slides.
Thank you. I'll only remind you that staff has requested a 10-minute, so I would assume that would be 10 minutes for you and Mr. Sharp included. And then if there's another public delegation, they would have 10 minutes. So staff will be able to let you know if you've gone over. So I'll turn it over to you now.
The 2-minute warning.
Yeah, thank you.
Sorry, did you want me to start, Madam Chair?
Yes, please go ahead, and staff has some other reason not to.
Okay, thank you. Yeah, I'm here for Mr. Sharp, who lives right next door to this proposal. Mr. Sharp lives at 509 Scenic Drive and has for many years. And we oppose this proposal very strongly. In fact, there's a bit of essentially a loophole in the bylaw that you're allowing structures this large, like even at 1,500 square feet. These are quite large structures, which might be suitable as an accessory structure on a 5, 10, 20, or 50 acre lot, but not on a 1.5 acre lot. And this, as I'm going to show you in the pictures, this is going to be quite the eyesore for Mr. Sharp. It's very much out of character with the neighborhood, contrary to what Mr. Cummings said, with all due respect, and contrary to what Ms. Angers said in her submissions. We completely disagree with their submissions. This is not a minor variance, it's major. And again, in our respectful submission, the county should go back and revisit its bylaws, because even 1,500 square foot accessory structures shouldn't be allowed on lots this small in a prestigious estate residential area of this county. People move there for a reason. It's a very nice, very picturesque neighborhood. These houses are not cheap, as you know, and we shouldn't be building structures which are essentially the size of a house as accessory structures on 1.5, 2 acre lots. And this is just, it's just extreme is what this proposal is. The committee, in my respectful submission, also needs to give proper heed to 17, I repeat, 17 objection letters. I don't appear before this committee a lot. I'm mostly in Superior Court and things like that. But, 17 objectors show up or have made submissions. They should be given proper heed to. And this includes retired planners. I think there's even a lawyer or two in there. They're obviously concerned citizens. How many people, have showed up or produced 17 complaint letters on a minor variance? Because the people are concerned about the precedent this will set. And I suggest they're even concerned about the policy in general, that at 1,500 square feet, such a structure is simply too large, and council should really go back to the drawing board and revisit its policies. If that's not something in the power of this committee to defer it back to council, and it's simply stuck with dealing with this proposal, I would suggest there be no amendments to the variance, to the bylaw. The definition of minor, according to the case law, and I'm referring to a decision of Toronto versus Romlek, ROMLEK, the definition of minor is lesser or comparatively small in size or importance. Well, there's nothing, comparatively small about this proposal once you start to really look at it. And I think that's what's generating the 17 letters of opposition. And this committee should be exercising its democratic prerogative, in my respectful submission, and enacting the will of the people, which is to say no to this kind of proposal until, for instance, county council takes a proper look at these policies. This structure is simply too big. It's 33% bigger than what the bylaw currently allows. It's 20% higher. My client's done a calculation, and his slideshow has even included calculations showing that this structure is basically 20 times as big as any other accessory structure in the immediate area, 20 times larger. Now, and as to whether or not, and this is very important, there's this notion that is he running a business or not? In our respectful submission, let's be blunt. We believe the neighbor is going to be running his business out of there. And in fact, he already is running his business out of there. As my client can attest to, he sees Mr. Narani virtually on a daily basis, loading and unloading his commercial vehicle from that garage. He's got stuff. What kind of a family needs those kinds of storage requirements just for residential use? They don't. So I'm asking this county to, or the panel to, use your common sense. This is not going to be used for residential use, for storage, a couple of vehicles. This is going to be used for his business. That's why he wanted it at 3,000 square feet in the beginning, but now it's 2,000. Even though that is a reduction, it's still unacceptable. And again, even at 1,500, it's unacceptable. But if that's the parameters we're stuck with, so be it. It shouldn't go any bigger than that. Now, this, as to, what this monstrosity, shall we say, because it is quite large. It's the size of a house, basically. What's it going to look like? Well, if Trevor, if you can call up page 9 of your slideshow, and I would ask this council to give due consideration to the slideshow and not just, a mere 10 minutes here. Like, this is this is very important for my client who's lived in the area for 16 years. And he's been told by his neighbor that he'd be happy with just 1,000 square feet. So this is just a representation, admittedly. I think my client's, he's pretty computer savvy. He would have done some crude measurements, but this is going to be the view out of his back deck. He could explain further about that, about the sizes of it. I believe this is relating to the upgraded or revised proposal. Is it, Trevor?
No, Madam Chair. To be fair, this is my original attempt. So when the building was 2,900 square feet, this is what I came up with. I mean, clearly I picked colors that are just going to point out exactly what we see. I'm a layperson. I'm not a planner or an architect. But there were statements made on the PJR, the planning justification report, which said things like there's a line of trees west of the property. Well, there's literally no trees in this area on Mr. Narani's property. He did plant some further back towards the back. The trees that I have there was a revised site plan done and it shows a number of trees, but you can see there's literally one big tree and then there's a bunch of little ones. These were planted in 2005 through the GRCA. And I did intentionally leave some of these areas the way they are. I didn't want it covered in trees because I do have such a beautiful view.
Now, Trevor, if you could go back a few pages to what the view is, the $1 million view, as you called it in your submission. And again, I'd urge council to give due consideration to this. I mean, if council or this committee allows these structures to be built throughout, which is the precedent we're setting here, it's going to be dotted with these, I would say, ginormous size, unnecessary, out of character, major structures. And again, in the state subdivision, state residential area, we see a small structure in the back of that house in the picture, but this is the view that's going to be destroyed by this structure. Again, use your common sense. Again, I'm not trying to say that disparagingly. This is a vast structure. It's just way too large for home use. The obvious inference is that Mr. Narani is going to be using it for commercial business. He's already, in our respectful submission, using his garage for that purpose. He has his commercial vehicle there. There's a picture of it, at all times with bright lights beaming into my client's property. So, the committee really, this should not be rubber stamped. This is going to set a bad precedent for a very sort of congenial, nice neighborhood. Again, a state residential, and which shouldn't have sort of barn-sized structures in it for storage. In terms of the 4 tests, I mean, again, this is a significant, major alteration. Council should be revisiting the whole policy altogether. Is it desirable for the appropriate development of land? Hardly. Again, having these kinds of giant structures almost as big as the house, that's simply not desirable in a residential context. And it's not appropriate for the use of this land. Now, in regard to maintaining the general intents and purposes of the bylaw and the official plan, again, the same thing. This is sort of a residential area. And it's simply this kind of a structure it's not for residential use. A residential accessory structure is maybe a couple of 100 square feet, actually, not 2,000 square feet. And then 20% higher than the bylaw would allow. I mean, essentially, this proposal makes a mockery, I would suggest, of all the reasonable limits that council has in place, which arguably are already somewhat excessive and should be revisited. So, in my respectful submission,
let me get 10 minutes, this guy, and then there's 7. I know this one presenter.
There's some background talk. I don't know.
No, that we are at the 2-minute warning.
Apparently, there's 17 letters.
So 17 letters have been submitted. I just heard that. And, if that's not proof or sufficient evidence as to why this proposal should be rejected, I don't know what is. And I think it's incumbent on the committee to carefully go through those letters. And, they're very adamant of the precedent that this was set for this nice residential area. Yep. They're very adamant that it's out of character with the area. And why is that? Simply because it is. We just completely reject the submissions. Unfortunately, with all due respect to Mr. Cummings, who I'm sure does good work, but this is just simply not one of those proposals that should be rubber stamped, and it should be rejected in its entirety, back to the drawing board. And in fact, the committee or the county itself should reconsider allowing the structures as large as even 1,500 square feet. That's basically my submissions. I don't know, Trevor, did you want to add anything else in the last 30 seconds?
I mean, I would like to correct one thing. I mean, I did meet with Mr. Narani 3 times before his house or during his house being built, and he telegraphed what he was going to do. He told me he was going to build a 3,000 square foot shop. And as you can imagine, of course, I got my back up right away because I knew how big 3,000 square feet is. It's much bigger than my house. And he told me, he showed me a site plan. So there was a comment made, respectfully, that there was a bylaw complaint, and that's what prompted him suddenly to decide to build an accessory building. That's not true, because there was a site plan originally for the house that includes the garage on it. And that's the reason why there's currently a driveway that goes all the way, probably 50 or 60 feet into the backyard of the property. There was a picture in my presentation that shows cars parked there. So now I'm looking at a driveway, I'm looking at cars, and the reason the driveway, I was told, is allowed to stay is because on the site plan, it showed that there would be an accessory building. So the idea, I feel like you're being misled in some cases. And I do feel like the planning and I mean, all due respect, the planning justification report made a number of statements that are clearly not true. So I'm simply amazed that we can get to this point where we're still considering things that, in my opinion, are factually incorrect.
How big is your house, Trevor?
My house is about 2,400 square feet.
So just a little bit larger than the proposed accessory building.
Yes, but probably not as tall, to be honest. And of course, every neighbor I talk to is completely open to the bylaws. The bylaws are the bylaws. No one is disputing them. Collectively, we have all followed the bylaws. There have been a number of accessory buildings built along Scenic Drive and in the surrounding area. And neighbors, I would say, generally collaborated with each other, probably told their neighbors what they were going to do and made sure that everyone was on the same page. And in this case, on August, I think it was August 10th, 2020, I made a bunch of notes. I was told a whole bunch of things about this was happening, and it's quite simply too bad. I mean, he was going to go for it. So my opinion is, if we can, let's stick to the bylaws. It is already significant enough. Or if there's a deferral, I'm very collaborative. I'm happy to talk about what we can do to satisfy both Mr. Narani's requirements and to minimize the impact that it has on me.
Thank you. I would assume staff has noted that the time has been up. I'll ask, was there another public delegation to speak to this application? Alyssa?
Thank you. No, there is nobody else tonight.
Okay, because my script gave another name, but I guess not. So I will now ask committee members, do you have any comments or questions to the public delegations? It appears there are none. I'll ask, are there any comments, final questions or comments to staff and or the agents and applicant? I believe there are none. I had a comment, final question to Ryan, if possible. If an accessory structure this size were to be allowed, would there have to be another permit applied to convert an accessory structure like this to an accessory residential unit? or would it automatically roll over to that status if washrooms, kitchen were added?
Madam Chair, the applicant owner would have to contact the county to confirm the eligibility for the accessory residential unit, and it would have to, I believe, obtain a permit for conversion for residential purposes.
Okay,
So
thank you.
caught on several accounts. Thank you.
Thanks. Then I'll ask the committee, do you have any, there's no final comments or questions? Then I will request of committee, is there a mover and seconder to put forth motion on this application? Are there any members within the committee who are willing to put forth a motion?
Member
Member
Emmett here.
Zuloff? Oh,
Member
ahead.
Emmett,
sorry, go ahead.
please go ahead.
Well, if, I was going to suggest that maybe we defer this until we get, I think we should have a little bit more information about the style of the building and everything else, if it's going to be that much oversized, before we could come to a decision.
I tend to agree with that. Is there someone who would second that motion?
Member Vamus, willing to second?
Thank you. Then I'll ask member Emmett, can you please state your motion?
I'll try, madam. Moved by myself and second by member Vamus that we defer this application for up to 2 meeting cycles to receive more information about the style of building, the appearance on the outside, the finishes, and et cetera, those kind of things. And that's application number A41-21-DM. No, I'm on the wrong one there.
No.
That's the wrong number. Sorry.
Sorry.
I'm on the wrong
A32.
page. Yep. A3221 RC. Yep.
Thank you, member Emmett. I'll now call the vote. So members, please indicate if you are in favor of the motion, starting with member Emmett.
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion to defer this application for 2 meeting cycles in order to obtain more specific details on this has been approved. I will ask staff to note that, and hopefully the agent can provide further, more detailed information. With that, I will now introduce the item 6.3 for application B7721AW and turn it over to staff for the presentation of the report and the recommendation.
Thank you. Can you just confirm that you can see my presentation?
Yes, Amanda, I can see it.
Thank you, MJ. So thank you through the chair. An application for a severance has been received for the lands municipally known as 571 Mount Pleasant Road. The subject lands are located within Mount Pleasant, excuse me, and are located on the west side of Mount Pleasant Road and are partially serviced with municipal water. In regards to the proposal, the applicant is specifically proposing to sever an area of approximately 1,835 square meters and a frontage of approximately 24 meters along Mount Pleasant Road, which satisfies the development standards for land zoned as suburban residential. And then due to capacity limitations, the applicant proposed a holding on the severed parcel as well. In regards to the official plan, the subject lands are designated as suburban residential and are located within the secondary urban settlement area of Mount Pleasant. And then in regards to the zoning bylaw, the applicant sought to rezone the subject lands through rezoning application ZBA 4021AW from agricultural to suburban residential to facilitate the severance, and to also place the holding on the severed parcel, which can be seen here. And then through circulation, excuse me, through circulation, 1 public comment was received seeking confirmation of drainage. I can confirm through the building permit process, a grading plan will be required which will require all drainage to be accommodated on the subject lands and to not be directed to the surrounding properties. In regards to my recommendation, I am recommending approval, and I'm happy to answer any questions the committee members may have.
Thank you, Amanda, for your presentation. Does the committee have any questions or comments to staff?
Member Emmett,
Go ahead.
just through you, Madam Chair, to the planner. This is a full-size lot. It's not undersized at all, according to the zoning.
Through the chair, this is a full-size lot, no relief through the rezoning application or through the Committee of Adjustment application has been received. The rezoning was just to rezone it from agricultural to suburban residential to facilitate the severance.
Thank you.
Are there any further comments?
Member Hamilton, through the chair to the planner. Just looking at this here, and we've got another lot severance in Mount Pleasant coming up in the next one. I noticed there was no fees for parkland on this application and or the fire regulations. Just wondering why that is.
Thank you through the chair. I'm not sure about parkland dedication. If it wasn't included as a recommendation and a condition, it should be included. And if it isn't, it will be included in the decision because that is a standard condition. So my apologies if that wasn't included. In regards to fire, it is located within the secondary urban area settlement of Mount Pleasant. So since it's not what we consider a rural lot, it doesn't need the fire protection fee since it will be municipally serviced and the fire officials can connect into servicing that's there should they need it.
Thank you.
Thank you, Member Hamilton. Are there any further comments or questions to staff? I would only comment, I had sent an email, and depending on how the motion is made, my suggestion was in some of the conditions to change the word for the various departments from understood to satisfied, where those departments like environmental planner had some input on it. If there are no further comments or questions to staff from the committee, I'll ask, is the agent or applicant present to make a presentation or add to the staff report?
Hello, committee. There's nothing more I'd like to add. I believe Ms. Wojcinski did a great job. Thanks.
And could I get your name?
Oh, Brandon Adeli.
Okay. Thank you. Does the committee have any comments or questions to the agent? It appears there are none. And is Mr. Lefebvre giving some input on this? No? Then I believe there are no public delegations registered for this application. So then I'll ask the committee, are there any?
Yes.
Madam Chair,
Yes?
we do have a public delegation for this.
Oh, sorry, yes, I see my note now. I do apologize. Please go ahead and state your name.
Thank you, Madam Chair and members. My name is Casey Pongrass, and I'm here with my husband, Steve Pongrass. We are the owners of 579 Mount Pleasant Road. Our property is directly behind the proposed lot. We're not objecting to the application. We do have some concerns that, as Amanda mentioned, with drainage,
From Hamilton.
with drainage into our horse fields directly behind the property. It does get quite wet, so we just want to be, we did get confirmation from Amanda that through the building permit process, a grading plan would be required. We were also wondering about the discharge from the sump pump. I don't know if this is going to be a walkout or if it will have a basement. This area is quite wet and has clay, so the houses around us that have basements do have sump pumps. So we would also want to be assured that that discharge from the sump pump is not directed towards our field as well. It is quite wet. Is there anything you want to add?
Yes, our sister-in-law is actually right beside the lot in question. And she has a sump pump right now, and it runs constantly right now. So, and all her water is coming into our backfield as it is now. So I cannot have another sump pump discharging over the back rear lot line. So if the grading plan is directed back onto the retained parcel, which the drainage right now does basically do that on his property, their property, I should say, then I would not have a problem with that. But I already have drainage tile there and I still can't get on the property. So that's my concern about that. And also with the MDS.
Oh, I had questioned Amanda through the rezoning process, whether MDS would apply here because we do have 6 stalls on our property. She had indicated that MDS was not applicable because it's already designated suburban residential. So, but that was our question, whether MDS would apply in this case. The other question I had was whether site plan control would be applicable on this property or not. I just thought of that one now. It's a single infill lot. I suspect that it's not applicable, but that was just a question I had. So thank you.
Casey's question, since it is an infill lot for only a single dwelling, site plan control is not applicable to this property.
Thank you.
Is there a possibility of getting a copy of the grading plan before it's approved through the consent?
Thank you for the chair. It's my understanding that building permits are typically not a public process, but I will confirm that with the building department and let Casey know whether you'll be able to see the grading plan or not.
Yeah, thank you. Like, we're not against the severance at all. It's just we just want to make sure that we don't have a drainage problem. Make it worse than it already is. That's all we really want to say.
Thank you.
Thank you for your time.
Thank you, and I do apologize for skipping over you. I'll ask the committee, do you have any final questions to staff or the public delegation or the agent? Since there are none, we will now move on to the motion and discussion, and I will request a mover and a seconder to put forward a motion on this application.
Member Zuloff, I can put forth a motion. There's a seconder.
Thank you. Do I have a seconder?
Member Hamilton will second.
Thank you. Can I get the motion from you for Member Zuloff and provide a reason for your motion?
Yep, moved by myself and seconded by Member Hamilton. That application B 7721AW be approved for the reasons outlined in staff report CA 21-106. It's consistent with the provincial policy statement. It's conformed to the policies of the growth plan and maintains the intent of the County of Brant zoning bylaw.
Thank you, members Zuloff and Hamilton. I'll now call the vote.
Before that, can we have those amendments in there where the parkland is check to see if it is in there or not, just to make sure it's consistent with the other applications that we've got?
Yes, I would agree with that. So could you provide that in your motion, Member Zuloff, with modified conditions?
Yes, I am moving to approve the application with the modified conditions as discussed.
Thank you. I will now call the vote, starting with Member Emmett. Please indicate if you are in favor.
Yes.
Hamilton?
Yes.
Zuloff?
Yes.
Vamus?
Yes.
Schmidt?
Yes.
Brown, yes. The motion to approve has carried with the modified conditions. The application has been approved. And we will now move on to item 6.4 on our agenda for application B6221AW, and I will turn it over to staff for the presentation of the report and the recommendation.
Thank you to the chair again. Can you just confirm you can see my presentation?
Yes, I can see your presentation quite clearly.
Thank you.
You're
So through the chair, an application for severance has been received for the lands municipally known as 729 Mount Pleasant Road. The subject lands are located within Mount Pleasant and are specifically located on the west side of Mount Pleasant Road and are similarly serviced with partially serviced with municipal water. In regards to the proposal, the applicant is specifically proposing to sever an area approximately 1,439 square meters with a frontage of 17 meters along Mount Pleasant Road. And then due to capacity limitations, the applicant also sought to place a holding on the severed parcel as well. This right here would be the severed parcel. In regards to the official plan, the subject lands are designated as suburban residential and are located within Mount Pleasant, which is a secondary settlement area. Excuse me. In regards to the zoning bylaw, the subject lands were rezoned through ZBA 3921AW, which is just awaiting ratification by council. They sought a site-specific provision for reduced frontage of 17 meters for the severed parcel and to place a holding on the severed due to capacity restrictions. And then in regards to public circulation, no comments were received. I am recommending approval of the application, and I'm happy to answer any questions the committee members may have.
Thank you, Amanda, for the presentation. I'll ask the committee members, do you have any questions or comments to staff?
Member Emmett again.
Please go ahead.
The frontage, is it meet the basic requirements, or is it undersized?
So through the chair, the frontage would be viewed as undersized, as 20 meters is required, but however, through the rezoning application, they sought relief for the frontage. So the rezoning applications placed a holding on the property, and then they also sought relief for 17 meters rather than the 20 meters. So that rezoning has been approved by the committee, or sorry, the Planning and Development Committee. It's just waiting for ratification at the end of this month.
Thank you.
Member Hamilton here, through the chair to staff. Looking at the environmental planning, there was a comment about the hedge, I believe, on the north side of the lot. Is that on the lot that's being severed, or is it on the neighbor's lot?
Thank you through the chair. I believe the hedgerow is on the neighbor's lot, from my understanding. But through the building permit process, they would still need to provide the protection that the environmental planner recommended in their comments.
Okay, thank you.
Are there any further comments or questions from the committee members to staff? And I'd only suggest that the word understood is changed to satisfied in those conditions 5, 6, and 7. Is the agent or applicant present to make a presentation or add any details to the staff report?
Hi, my name is Rob Innes. I am the homeowner. I don't have anything to add to Amanda's report, but I'm here to answer any questions if necessary.
Thank you, Mr. Innes. I'll ask the committee, do you have any questions to the applicant? I don't believe there are any. And on this one, I do believe there are no public delegations registered to speak to this application.
So the chair, there are none.
Thank you, Alyssa. And I will just ask of the committee, are there any final questions or comments to staff and or the applicant?
Member Emmett, as with the previous application, was the fire requirement in the condition of list of conditions? The
Through
payment?
the chair, I can confirm that the fire
Or the-
servicing fee is not required because it's within Mount Pleasant,
Right.
but the parkland dedication fee will be added because that is a standard condition. Again, my apologies for not including that in the
Thank you.
recommendation.
Thank you.
Thank you. So there are no further comments or questions on this application from the committee. I'll now request a mover and seconder to put forward a motion.
Member Hamilton here will move.
And do I have a seconder?
Member Schmidt.
Thank you. Please go ahead, Member Hamilton.
Moved by myself, seconded by member Schmidt, that application B 62-21AW be approved with the amended conditions that have been put forth because it does meet the County of Brant official plan information.
Thank you, members Hamilton and Schmidt. I'll now call the vote. So members, please indicate if you are in favor of the motion, starting with member Emmett.
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The application has been approved. Thank you, committee and staff. I will now introduce the item 6.5 for application B7821AW, and I will turn it over to staff for the presentation of the report and recommendation. And I will note that member Zuloff is recusing himself on this application. I can see the screen. Thank you, Amanda.
Question. All right, so thank you through the chair. An application for a lot line adjustment was received for the lands municipally known as 209 Pleasant Ridge Road and 171 Pleasant Ridge Road. The subject lands are located on the west side of Pleasant Ridge Road and are privately serviced. In regard to the proposal, a lot line adjustment with an area of approximately 1 hectare was conditionally approved by the committee in September 2020. And then due to conditions lapsing, the applicant has reapplied for the same lot line adjustment and has provided commentary in their submission materials on the status of each condition. In regards to the official plan, the subject lands are designated as agricultural, which contemplates for minor lot line adjustments. I do note that no new residential building lots are being created, and the area to be severed and merged are not farmable due to the existing conditions and the irregular shape. And then in regards to the zoning bylaw, the lands to be severed and merged are zoned as agricultural, and the retained parcel was rezoned, the rezoning application ZBA 321AW, to recognize an undersized farm parcel, which was a condition of the original September 2020 application. And then in regards to public circulation, no comments were received. I'm recommending approval of the application, and I'm happy to answer any questions the committee members may have.
Thank you, Amanda, for the presentation. Does the committee have any questions or comments to staff on this application? It appears there are none. Oh.
Member Hamilton here through the chair to staff. Just wondering, it looks like we're taking a fair bit of farmland and donating it to the county on both of the lines that are Pleasant Ridge and Arthur Road. Was that in the previous one? Were they included in the previous, or has this been added since that one from 2 or 3 years ago?
Thank you to the chair. Member Hamilton, can you just confirm you're referring to the road widening requirements?
Yes, it's on condition 7.
Yep. So through the chair, in the original severance application, the road widening was not identified, but through the rezoning application of the retained parcels at BA 321AW, it's my understanding that road widening was identified through that application. Just typically road windings are identified through the severance, and that's why it's been added to this application.
Okay, thank you.
Thank you, Member Hamilton. Are there any further comments or questions to staff? I guess there are none. So is the agent or applicant present to make a presentation of their own or add any details to the staff report?
Hello, Robert Lefebvre. I'm here. Mr. Neil Sisler is here as well, and my law student Jason Timms is here as well. But we're sorry to be back in front of you to redo this application, but we're hoping to get an approval again. I believe the failure to complete the conditions is a COVID and economic fact. The surveyors were also busy and depleted in staff that we couldn't get our survey work done in time when the second application required us to get the road widening parts surveyed up correctly for the application. We don't think that the piece of land is going out of agricultural use. Our client indicates he hopes to grow something. I can't remember what it is now. What are you growing, Neil? I think we're talking about not onions, but sorry, just forgetting the moment. Anyway, we're hoping to still use this land. It's a smaller thing that fits a sort of a hobby farm situation. Didn't fit the real farmers situation because large equipment wasn't turnable in that small area. So it's a convenience between neighbors. I think it'll work out well, and we're looking for approval.
Thank you, Mr. Lefebvre. Does the committee have any comments or questions to the agent? It appears there are none, and I believe there are no public delegations registered to speak to this application. So then I'll just ask the committee if there are any final questions or comments to staff or the agent. Since there are none, I will request a mover and seconder to put forward a motion.
Member Emmett, seeking a seconder.
Is there a seconder?
Member Schmidt.
Thank you. Please go ahead, Member Emmett, with your motion.
Make sure I got the right number this time. Moved by myself and second by Member Schmidt that application B7821AW be approved, which is approve the previous conditions, as it's just a renewal of the previous approved application.
And you did say with the modified conditions.
Correct.
Thank you. I will now call the vote. Members, please indicate if you are in favor of the motion, starting with Member Emmett.
Yes.
Hamilton,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The application has been approved. Thank you, committee.
Thank you very much.
Welcome. You're welcome. I will now introduce item 6.6 for application B7521SL and turn it over to staff for the presentation of the report and the recommendation.
Great. Can you just confirm that you can see my screen?
I can see you right now, Shannon, but I don't see your screen.
No problem. There we go.
Okay, I can see your screen now. Thank you.
Wonderful. Thank you so much. So good evening, Committee of Adjustment and members of the public. This is a severance for lands located at 343 Blue Lake Road within the geographic township of South Dumfries. This is to sever a dwelling deemed surplus with a frontage of approximately 51 meters in an area of approximately 0.46 hectares. The retained lands have an area of approximately 56.8 hectares. The subject lands are located on the north side of Blue Lake Road, having frontage along the north side of Blue Lake Road, as well as the south side of Scenic Drive. The subject lands are designated as agriculture and natural heritage within the County of Brant official plan. The lands to be severed are designated agriculture. The proposed severance is in conformity with the County of Brant official plan for the following reasons. No new residential building lots will be created, as the retained lands are to be rezoned to prohibit a dwelling. The retained lands are expected to be farmed as part of a larger farming operation. The severed and retained parcels have frontage along Blue Lake Road. The minimum distance separation formulae is able to be met, and the severed parcel is large enough to accommodate private servicing. The subject lands are zoned as agriculture and natural heritage within the County of Brant zoning bylaw 6116. The lands to be severed are within the portion zoned as agriculture. The application complies with the County of Brant zoning bylaw, as the severed and retained lots satisfy the development standard for the agriculture zone. The retained lands will be rezoned to agriculture with a site-specific provision to prohibit a dwelling and to request relief from the deficient lot frontage. No public comments were received at the time of writing the report. And the applicants will be required to apply for a minor rezoning to prohibit a residential use on the retained parcel, as I mentioned, as well as to request relief for the deficient lot frontage. It is my professional opinion that the requested consent application has merit, is in keeping with the general intent and purpose of the zoning bylaw and official plan. I am recommending approval of the surplus farm dwelling severance, subject to the attached conditions. Thank you, and happy to answer any questions.
Thank you, Shannon. Does the committee have any questions or comments to staff on this application?
Member Zuloff, through the chair to staff. I'm just wondering about, in our materials for this application, as far as the diagram goes, there's kind of a close-up detail, the severed parcel over the map view. And I'm just noticing on what's shown to be the severed parcel seems to be cutting through a number of buildings, like the property boundaries. I'm just wondering, is that accurate at all? What's in our materials? And if so, what's going to happen to those buildings? Are they being removed? Encroachment agreement? What's the...
Through the chair to Member Zuloff. So actually I included as a condition of the consent application is to remove those buildings. And when I spoke with the the agent, they informed me that they are going to be removed prior to the finalization of the consent.
Okay, thank you.
I would ask Shannon, then that's the reference in condition 4 where you're calling them storage containers, because
Correct.
I don't recall seeing actual buildings.
No, they are storage containers.
Okay, thank you. Does the committee have any more comments or questions?
Member Hamilton here, through to the staff, and it's to do with that same number 4 one. There seemed to be a lot of excessive big lumber logs. I don't know what it is. Is that to be taken cleaned up prior to the severance going through?
Are you referring to the retained parcel or the proposed severed parcel?
The retained parcel.
To the best of my knowledge, those are related to the agricultural operation.
Okay, they were just strange looking, that's all. I haven't seen many farmers work that kind of stuff, but that's okay. Just as long as I understand. Thanks, Shannon.
No problem. Thank you.
I believe, just to answer your question, Member Hamilton, because I drive by there many times. I believe there's been an attempt to clean up quite a bit of material around there. So, and then winter has set in. So I think that's why it appears to be on hold right now. Are there any further questions or comments to staff? Is the agent or applicant present to make presentation or add any details of their own to the staff report?
Hi there, my name's Kate Wills. I'm from MHBC Planning. I'm an associate with MHBC. And also with me today, I have Rachel Nizer from our office, who's a planner. I just wanted to thank Shannon for her presentation. I think it was very thorough and she has answered the questions well. I just wanted to let you know I'm here to answer any additional questions. We have reviewed the staff report and we do agree with the conditions that are imposed and the recommendation to the committee this evening. So if you have any questions, I'll do my best to answer them. That's all I have today. Thank you.
Thank you. Does the committee have any questions or comments to the agent? I believe there are none. So I believe there are no public delegations registered to speak to this application. So I will move on to request a motion and any discussion. Is the
Member
committee
Hamilton here.
okay? Are you willing to put forward a motion?
I will move it if I can have a seconder, please.
Is there a seconder in the committee?
Member Vamus will second.
Thank you. Please go ahead, Member Hamilton, with your motion.
Moved by myself and second by Member Bamus that application B75-21SL be approved with the report number CA-21-108 on the conditions, because it does meet the obligations of the County of Brant and the planning and zoning.
Thank you, members Hamilton and Vamus. I'll now call the vote. So members, please indicate if you are in favor of the motion, starting with member Emmett.
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt,
Yes.
Brown, yes. The motion has carried. The application has been approved. Thank you, committee and staff and the agent.
Thank you very much.
You're welcome. I'll now introduce the item 6.7 for application B44 to applications B44 to B4821DN and turn it over to staff for the presentation of the report and the recommendation. And I can see your screen, Dan. Thank you.
Perfect. Thank you, Madam Chair. This is a consent application, as you noted, involving application numbers 44, 45, 46, 47, and 48 for property located at 29th 13th Concession Road in Scotland. And I believe our applicant and agent are present this evening, and staff are recommending approval of the application. The subject lands, as I mentioned, are located partially in Scotland, located on the south side of 13th Concession. The total area for the subject lands is approximately 65 hectares, having over 1,000 meters of frontage along 13th Concession. On the right side of your screen, the aerial image, there's a white dashed line cutting through the subject lands, which are identified in red. And that line delineates the boundary of the second, or the Scotland settlement area boundary. And there's approximately 36 hectares of land within the boundary, and the remaining lands are located without or outside. Just to note, the lands highlighted in yellow, I just wanted to identify those are lands that this committee had previously dealt with through consent, and you'll be dealing with kind of the next piece over as part of this application. So again, through in the official plan land use, we can see the settlement area of Scotland a little more clear now. That beige area, again, the subject lands are highlighted in red. The land use designation as it relates to this application, a suburban residential, and anything outside of that settlement area is agricultural. Our zoning bylaw, little bit of history. The subject lands recently went through a zoning bylaw amendment application to rezone the portion that we are dealing with this evening, which is this red hatched portion. So approval was received on that portion to rezone it from agricultural to suburban residential to allow to facilitate this consent application to create lots. This is the roughly 5-acre parcel referred to in the report. The rest of the area within the settlement area was also subject to a zoning application where the request was to rezone from agricultural to suburban residential, place a holding on those lands for future development. And this portion of the application was refused. And I'll just note to the committee that that portion of the decision, the larger portion, has been appealed to the Ontario Land Tribunal. But I'll remind the committee that we are simply dealing with a small portion hatched in red this evening. So the proposal, as I mentioned, is to create 5 new suburban residential lots within the secondary settlement area of Scotland. The image identifies the retained lands in both the pink area and the tanned area outside of the settlement area. And the area proposed for the 5 lots is located along 13th concession, directly adjacent to the 4 lots severance back in 2020. So it's just a continuation of linear development along 13th concession. The minimum lot size in the suburban residential zone is 3,000 square meters. The minimum frontage is 30 meters. The applicants have demonstrated that each lot will meet and exceed those minimum requirements. Also note that the retained lands will meet and exceed the minimum requirements for agricultural parcel size, where 40 hectares is required and 63 hectares is being maintained. So here's a closer look of a really conceptual layout of what, how each site could be developed. I will note that we did receive some comments from our operations division late yesterday, which I did forward to the applicant. No game changers in terms of what their comments are. Everything has been captured already in conditions of the consent application. So I'm just going to run through a few of those conditions with the committee just to call out some important conditions that have been triggered by comments received by our engineering division and our operations division. So condition number 2 is dealing with, again, making sure that zoning bylaw amendment application goes through and is finalized with no appeals. So as I mentioned, a portion of the previous zoning application was appealed to the Ontario Land Tribunal. However, this portion of the application can move forward because it did receive approval, and the decision, each part of the application received a separate decision. So this portion can move forward, just capturing that in the condition for just to keep everything in line and accounted for. Condition number 4 deals with the request for reserve lands to restrict access where safe sightlines cannot be achieved, and road widening requests. This is consistent with the previous applications back in 2012. Condition number 5 is requesting an overall site development plan and a development agreement be registered on the properties. That site development plan is looking at the 5 lots holistically to ensure that there is adequate drainage and access is being provided in the most efficient and safest way. I'll note that the operations division's comments do identify the desire to pair entrances to reduce the number of driveway access points along 13th concession. That is a standard request of both our operations and engineering divisions, and that's something that we'll look to confirm as part of that site plan review. Condition number 6, so the conditions included in the staff report did note that an archaeological assessment is required. I will confirm that the archaeological assessment is not required. This mapping, or the subject lands are located outside of our official plan mapping, which indicates potential archaeological resource areas. And we did not receive the request for an archaeological assessment through circulation of the application. The final one there is proof of potable water. That's a standard request on any development with that's proposed on private services. and our operations division comments, which were provided to the applicant, just elaborate on how that is to be done, how they would satisfy that condition. So overall, no further changes to any conditions other than the removal of condition number 6 related to archaeological. So with that being said, as I mentioned, the comments received through technical circulation have been included in the staff report and are reflected in the conditions. No comments were received from the public as part of this public circulation. We did have some questions of clarification as part of the rezoning application, but again, a lot of those questions were filtered out through the previous application. Review of this consent application proposing the creation of new lots has had regard for section 5124 of the Planning Act and the criteria to be considered when reviewing consent applications. The lot creation is compatible and consistent within the context of the existing development. This application will facilitate limited minor rounding out of development on private services within the secondary settlement area of Scotland. The application is consistent with provincial policies of the provincial policy statement. The application is in conformity with the policies of the growth plan, and the application is in conformity and compliance with the Fisher Plan and zoning bylaw, and therefore it's my professional recommendation to the committee that this application be approved, subject to the conditions as attached and as amended. Happy to answer any questions.
Thank you, Dan. I'll ask the committee, do you have any questions or comments to staff?
For Hamilton here, through the chair to staff. Dan, on condition 11, you've got stamping 2 years from the date of a written decision. I think most of the ones in the past have been 1 year. 1 year. Is that a change that the county is making right now, or is this an exception to this application?
No, actually, through you, Madam Chair, to Member Hamilton, this is a legislative change that has come into effect this year. A change in the Planning Act that does allow 2 years rather than 1 year to satisfy conditions. So that will be a standard change moving forward and should be reflected in all consent applications.
Thank you.
Are there any further questions or comments from the committee to staff on this? I have a question. I recall in those discussions we had about extending it to 2 years, which that time we had the discussions. I thought that the archaeological assessment had to apply to most severances that were within so much of a distance to Grand River. So what I didn't quite catch your reason as to why we would be dropping condition 6.
Yep, through you, Madam Chair, we do have mapping in our Fisher Plan as Appendix A, I believe it is. It's identifies kind of blobs on a map that are reflective of any areas that may have potential archaeological resources. And it's my understanding through my time here at the county that the way that mapping was generated was based on some criteria: proximity to water courses, significant water courses, and elevation changes, things like that. So based on that mapping that's been in our Fisher Plan since 2012, these subject lands are located outside of that mapping. So like I mentioned, we did not receive any requests for archaeological through the technical circulation, so that condition can be removed.
So who could request an archaeological assessment?
Through Madam Chair, yeah, so we do circulate our 6 nations, and Mississaugas of the First Credit Nation group. That request could come from those groups as well.
Okay, I just wondered because in Oakland, which isn't too far from there, There is, I believe, the park, which has a historic plaque, and I think it's about the War of 1812. So maybe the war never made it that far. So I was just curious as to the archaeological assessment requirement. I will ask, does the committee have any further comments or questions on this? Is the agent or applicant present to make their own presentation or add any details to the staff report? I see Mr. Phillips.
Good evening, Madam Chairman, members of the committee. Bob Phillips representing Michael Haley on this application. This is an additional parcel of land. We've been through severance on some initial lots that was before this committee a few years ago. We're seeking the committee's approval for these severances. We've read the planning staff report and are very supportive of the conditions and the revised condition to eliminate the requirement for the I can't say that word. The archaeological assessment of the lands. That was not part of any conditions for the previous severance. We're just seeking support of the committee tonight.
Thank you, Mr. Phillips. Are there any questions or comments from the committee to the agent? I believe there are none. And are there any public delegations registered to speak? I believe there are none for this application. Are there any final questions or comments from the committee members to staff or the agent? I believe there are none. I will now ask the committee and to provide a mover and seconder to put forth a motion. Are there any members who wish to provide a motion on this application?
Member Emmett, seeking a seconder.
Do we have a seconder?
Yeah, Member Zuloff, I can second.
Thank you.
Okay, moved by myself, second by Member Zuloff, that application B41, B48, 2B48-21 DN be approved as it meets the county requirements and subject to county planning with the modified conditions as circulated.
Thank you, members Emmett and Zuloff. I'll now call the vote. So members, please indicate if you are in favor of the motion, starting with member Emmett.
Yes.
Hamilton,
Yes.
Zuloff,
Yes.
Vamus,
Yes.
Schmidt. Member Schmidt, you're muted. Do you vote in favor or oppose the motion on the table? Member Schmidt? I believe. Can you acknowledge? Do you hear me, Member Schmidt? I will go to Member Brown. Yes. I believe there are enough members supporting this. The motion has carried. The applications have been approved. Thank you, members.
Thank you very much.
Thank you. I will now move on to item 7 on our agenda. For the next meeting date is expected to be March 17th, 2022, St. Patrick's Day. And we will move to item 8 in our agenda, adjournment of this meeting. May I please get a motion to adjourn the meeting?
Member Zuloff, I can make that motion.
Thank you. Do I have a second?
Member Emmett.
Thank you. Member Zuloff, can I get your motion?
Yep, moved by myself and seconded by member Emmett that the meeting of February 17th, 2022 be adjourned.
Thank you, Member Zuloff and Emmett. All those in favor?
Yes.
Yes.
Member Schmidt? I'll assume it's yes. Okay. I now declare the meeting for February 17th adjourned. Thank you and have a good night.
Thanks. Good night.
I don't